Dear students, let us continue the law class. In the last class, we have seen that a proposal, when accepted, becomes a promise, and a set of promise forming the consideration for each other is an agreement. So, in order to form an agreement, there should be reciprocal promises. Promised by one person and promised by another person. The promises are giving something and taking something. One person is giving a promise to another person, and that person is also giving another promise to the first person. So these are what is called reciprocal promises. For example, if A agrees to sell his computer to B for 50,000 rupees, A agrees to part with his computer to B, and B agrees to part with his 50,000 rupees to A. A is giving a computer to B, and B is taking the money. B is giving 50,000 rupees to A and taking the computer from B. Giving and taking. These are the reciprocal actions, positive actions. It may be negative actions as well. Anyway, as we have already seen that an agreement without consideration is no consideration at all. No valid contract can be made without consideration, what is called nudum pactum, contract without consideration. Therefore, we can say presence of consideration is one of the essential element of a valid contract. Their consideration simply means something in return. In Latin terms, it is called quid pro quo. Quid, quid, pro, pro, quo, quid pro quo. Something in return. That is what it means. So consideration is giving something and receiving something. So something, if you give something, the other person is returning something to you. If the other person is giving something to you, you are giving, returning something to him. So something in return, or what is called quid pro quo, is what is called consideration in a contract. And presence of consideration, as I have already told you, is an essential element of a valid contract. The giving and taking policy, it may be either some benefit conferred on one party or some detriment suffered by the other. Detriment here means loss. In the above example, when A loses his computer, he is benefiting a certain amount of money. Similarly, when B loses his money, he is benefiting receipt of a computer and as such. So therefore, the consideration may be either some benefit conferred or some detriment suffered. The benefit conferred or detriment suffered is the consideration for each party. The general rule in India is that a nudum pactum, that is An agreement without consideration is void, that is not enforceable. Therefore, we can say an agreement contains reciprocal promises or set of promises. One promise is the consideration for the other promise and vice versa. And then, of course, there is a definition of consideration by the Indian Contract Act. Section 2, Clause D defines consideration as quotation when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something. Such act, abstinence, or promise is called a consideration for the promise. This is the definition of consideration given in the Indian Contract Act. It is clear from this definition that under the Indian laws, consideration may be past, present, or future. Because the definition says the promisee or any other person has done or abstained from doing. Abstain means not to do something. Done or abstained from doing. Here, done or abstained means the consideration is past. Does or abstains from doing. Here the consideration is present. And promises to do or to abstain from doing. Here the consideration is future. Therefore, as per the definition itself, consideration may be past, present, or future. Then what are the other essential elements of a valid consideration? In simple words, consideration is the doing or not doing something which the promisor desires to be done or not to be done. In the definition, you have seen that consideration means when at the desire of the promisor, we will discuss it later, the promisee or any other person has done or abstained from doing. And it is at the desire of the promisor. So, doing or not doing something which the promisor desires to be done or not to be done. And it must be at the desire of the promisor. Whether doing it or not doing it, it should be at the desire, at the instance of the promisor. And the consideration may move from the promisee or any other person. That means it is not compulsory that consideration should move from the promisee only. If the contract may be between the promisor and the promisee, the consideration may move from, not necessarily from the promisee, but may be from any other person as well. That is why in the Indian contract rules we say there can be stranger to the consideration. Consideration may be from a stranger, a third party. So, it may move at the desire of the promisor, move from the promisee or another person. And another element essential is that It need not be adequate, but should be real. It should not be illusory. For example, A agrees to sell his computer to B worth rupees 50,000 for 5,000 rupees. The computer is worth 50,000, but he agrees to sell it to the other party for 5,000 rupees. So actually the consideration is not adequate when we consider the value of the computer. But the adequacy of consideration is not a matter here. But it should be real. That at least that 5,000 rupee should be received by the promisor from the promisee. So it should be real. So it is doing or not doing something, and it must be the desire of the promisor. It must move from the promisee or any other person, and it should be, it need not be adequate, but should be real. These are the important essentials of a valid consideration. The essence of consideration is the detriment suffered or burden taken by the promisor. It may sometimes happen that the promisor may or may not derive any benefit at all. Let us take an example. A promises to carry B's goods free of charge. A promises to carry B's goods free of charge, and B allows A to do it. Here, what is the detriment or disadvantage which B suffers in parting with the goods? B allows A to take his goods, or we can say the luggage, and A already agreed to do it at free of cost. Now B is not giving anything. Then what is the detriment he lost, he suffered? Here the detriment which B suffers in parting with the goods is sufficient consideration against his promise. So he is allowing A to take his goods. His luggage is taken by A, and B allows him to do so. So B has to part with his luggage. He should allow A to take it, even though freely. And it is a detriment suffered by B. That detriment itself is the consideration for consideration against his promise. Let us take another example. X promises to maintain Y's child, and Y promises to pay 10,000 rupees per month to X. Here, the promises of each party is the consideration of the other party. The promise of X to maintain Y's child is consideration for Y, and the promise to pay 10,000 per month to X is the consideration for X. So there are two promises, promise by X and promise by Y. What is the promise of X? To maintain Y's child. What is the promise of Y? To pay 10,000 rupees per month to X. So there are two promises, one by X and the other one by Y. X will maintain Y's child and Y will pay 10,000 per month to X. So these reciprocal promises form the consideration for the promises by each of them. Suppose in another example we can say C promises his debtor D. C promises his debtor D. Debtor D is the debtor of C. And C promises his debtor D not to file a suit against him if D agrees to pay 10,000 more on the principal amount. Suppose D owes C certain amounts. When there is a promise to pay certain amount much more than the actual amount due, and the other party agrees to pay more amount, why he is agreeing to pay more amount? So that the creditor, that is C here, will not file a suit against the debtor D. So for not filing a suit against the debtor, the creditor is agreeing to pay 10,000 rupees more. The debtor agrees to pay more amount to the creditor. To put it more clearly, C is the creditor and D is the debtor. C promises his debtor. If amount is not received, generally a suit or case will be filed against the person from whom amount is due. Here, the person who has to receive the amount from the other party promises that if the other party agrees to pay more money than what is due, no suit will be filed against him. So here the promise is for not doing something, or what we can say abstinence. So here the abstinence of C in not filing a suit against D is the consideration for D's promise. What is the D's promise? He will pay more amount than what is due. What is the promise by C? He will not file a suit against D. So here we can say C will not file a suit against D. That is abstinence for not doing something. That is the consideration for giving more money by D to C. So we can say there is a detriment suffered or burden taken by the promisor. That is what is called the consideration. In another example, A guarantees B. A guarantees B for payment of price of goods which B wants to sell to C for 1 month credit. Put it in a different way. Let us say C approaches B for purchase of certain goods on credit for 1 month. B wants some guarantee. A stands as surety for C. C is the person who is purchasing goods from B, and the purchase is on credit basis. B wants some guarantee or surety. Here A is the guarantor, is guaranteeing the payment of the price of the goods which B may sell to C. Here, selling of the goods on credit by B to C is the consideration for A. A is simply giving a guarantee. What is the consideration for A in giving the guarantee for C? We can say A is guaranteeing or standing as surety for C. So this happens generally in so many cases. Suppose your friend approaches for you to stand as a surety for taking a loan from bank. You agree. And ultimately you become guarantor for your friend's loan from bank. Now the question is, what is your consideration here? The bank's willingness to grant loan to your friend on your guarantee is your consideration for the promise. In another example, let us say X has an electrical shop. Y wants to open a similar shop nearby. So it will definitely adversely affect B's sale. So B approaches C and offers certain sum for not opening the shop nearby and shift it to a distant place. And C agrees. What is the agreement by C? C agrees to abstain from opening the shop nearby to B's shop. And that abstinence is the consideration for abstaining C from not opening the shop near to B's shop. So for abstaining from opening the shop nearby, C should have some consideration. What is the consideration for C? Of course, B has offered certain amount. For what? For abstaining C from opening the shop nearby. And that is the consideration for B. So, when we examine these examples, we can very well understand that the essence of consideration is the detriment suffered or burden taken by the promisor. Then let us see what are the legal requirements of consideration according to the definition. We have seen that consideration must move at the desire of the promisor. That is how the definition begins. When at the desire of the promisor. Thus, an act done at the desire of a third party is not a consideration. It should be at the desire of the promisor. At the desire of the promisor. Let us take an example. In Durga Prasad versus Baldev, the plaintiff Durga Prasad constructed certain shops in a market, and it is as requested by the district collector. At the request of the district collector, Durga Prasad constructed certain shops. Then Baldev occupied one of those shops and promised to pay commission on the goods sold in the shop to Durga Prasad. So there is an agreement between now DP and Baldev. What is the agreement? B is the shop owner. He agrees that whatever goods are sold in his shop, certain commission will be paid to the plaintiff Durga Prasad. But B failed to pay the commission, and then Durga Prasad filed a suit against B. The court examined the case and held that here the construction of the shops in the market was not at the desire of the promisor B, but at the desire of the district collector. Hence, there is no consideration for the promise by B that he will pay commission. There is no consideration for the promise by B, and hence, as in the absence of consideration, there is no valid contract created in this case. That is the decision by the court. So what the court says is that the consideration must move at the desire of the promisor. Here, the consideration in the form of construction of the shops were at the desire of the district collector. Not at the desire of Baldev. That is what the court decided. So the first legal requirement is that consideration must move at the desire of the promisor. And the second one is that consideration may move from promisee or any other person. Promisee or any other person. It is not necessary that the consideration should move from the promisee to the promisor. In Indian law, consideration for a promise may move either from the promisee or any other person, that is from a third party. So that means there can be a stranger to consideration, but not a stranger to contract. Stranger to contract, what is in other words called the privity of contract, that we will discuss it later in detail. But there can be a stranger to consideration. That is why it may move from promisee or another person. In Chinnaya versus Ramaya, an old lady, gifted her properties to her daughter Ramaya. Chinnaya is an old lady. She gifted her properties to her daughter Ramaya with the direction to pay certain sum as annuity to her uncle Chinnaya. Chinnaya is not the old lady. Chinnaya is the uncle of Chinnaya. Chinnaya's uncle, the property was transferred by Chinnaya to Ramaya. Ramaya is the daughter of the old lady, and the old lady wanted to pay certain annuity to her brother Chinnaya every month. Chinnaya is thus the uncle of Ramaya, the lady to whom the property was transferred. On the same day, the daughter made a promise with her uncle, to whom commission has to be paid. And what was her promise? That she would pay the annuity fixed by her mother. So there was such an. So the mother wanted to pay annuity to her brother. Daughter also made a similar promise to her uncle that she will pay the annuity. But what happened is that the daughter failed to pay her uncle the commission as promised. So the uncle, Chinnaya, who is the he has filed a case against his niece. Then she claimed that, contended that the plaintiff had not furnished consideration, she had no right of action. The uncle filed a suit against the niece. The niece contended that since the plaintiff uncle had not furnished the consideration, he had no right of action against her. See, you have to first properly understand the agreement between her daughter and herself. The name of the old lady is not given in the example. The case is between uncle and niece, Chinnaya versus Ramaya. Then Ramaya is the daughter of the old lady. Chinnaya is the brother of the old lady. The old lady gifted her properties to her daughter Ramaya with a direction to pay a certain sum as annuity to her uncle Chinnaya. She failed to pay. So the agreement between the mother and daughter. But on that day itself, daughter made a promise with her uncle that she would pay the annuity, but failed to pay. Then the uncle filed a suit, and when the niece defendant contended that the plaintiff had not furnished the consideration, therefore he had no right of action. The court held that the consideration for the promise by her has moved from her mother. She promised her uncle to pay this, but she herself claimed that there is no consideration, therefore I have no liability to pay you the commission, and uncle had no right of action. That was her claim. But the court held that here, when she had promised to pay a commission to her uncle, the consideration for that promise has moved from her mother. Suppose mother is A, mother A, and hence she is liable to pay the annuity. So why the court has come to such a conclusion? Because under the Indian law, the consideration may move from the promisee or any other person. That is why here the consideration for the promise has moved from his mother, and there can be a stranger to consideration. Therefore, the promise is valid and her uncle has won the case. Then a consideration may be executed consideration or executory consideration. Executory. The promise by one party may be consideration for an act by the other party. That we have already seen. The promise by one party may be the consideration for an act by the other party. That is promise to promise. A consideration which consists in the performance of an act is said to be executed. Performance of an act, if that act is done, consideration on the part of that party has been done, performed. It is executed. It is already done. Executed in the means it's already done. For example, you go to a shop and buy certain goods on credit. The shopkeeper has given you goods worth 1,000 rupees and you promise to pay it after a week. So here, as far as the shopkeeper is concerned, he has already executed his promise. He has given the goods on credit. So it is an executed consideration. But as far as you will pay the amount only after a week. So it is to be given, to be executed. Therefore it is called executory. A pays 10,000 to B and B promises to deliver certain quantity of rice within a month. In agreement between A and B. A pays 10,000 to B. B promises to deliver certain quantity of rice within a month. Simply examine. A has already performed his part. He has already paid the amount to B. But B will deliver the goods, the rice, only after or within a month. Here, the consideration paid by A is executed. The consideration promised by B is executory. When one party has already executed his performance, it is executed. When the other party's performance is pending, it is called executory consideration. Now, another rule is that consideration need not be adequate. The meaning itself is something in return for something. Something in return need not be equal to the something given. The consideration must be something which the law would regard as having some value. It should not be illusory. A agrees to sell his scooter worth 25,000 to B for 2,500. A agrees to sell his scooter worth 25,000 to B for 2,500. You know, the scooter is worth 25,000, but A agrees to sell it to B for 2,500. So 2,500 is not the adequate consideration for the scooter, but still it is a valid consideration and therefore it is a valid contract. Therefore, the ultimate rule is that the consideration need not be adequate, but it should be real. Similarly, performance of an act which one is legally bound to perform cannot be consideration for a contract. Performance of an act which one is legally bound to perform. Take the case of a witness. When X is witness in a case, We need not pay any money to the witness. A witness, when a person becomes witness in a case, he is legally bound to appear before the court and give witness of the incident. If you agree to pay or promise to pay any money to that witness, it is illegal. Why? Because performance of an act which is legally bound to perform does not require consideration. When you are a witness in a case, the party to the case, none of them should pay you money for giving the witness. Similarly, suppose you approached an advocate for arguing your case in the court, he has done so and the case is won. There is an agreement between you and the advocate to pay a certain amount as fees. But when the case has won, the advocate cannot claim more money than what is prescribed, because he is not legally bound to claim such an amount. So performance of an act which one is legally bound to perform cannot be consideration for the act. The consideration should be real and not illusory. Suppose somebody approaches you and offer you certain amount, and you promise that person to pay a certain amount if he discover treasure for a price. Promise to discover treasures. Somebody approaches you and your property there are treasures, and he will find it out for you if you pay him certain amount. It is not sure that there will be such a treasure in your property. It is not real, it is only illusory. And consideration for doing such an act is not consideration at all. And another thing is that consideration must not be unlawful, immoral, or opposed to public policy. 3 things. Consideration must not be unlawful, 1 thing. It should not be immoral, 2nd thing. It should not be opposed to public policy.